Hello everybody, welcome to actually our first Law After Lunch lecture this summer semester. Happy to see all of you, students, guests, international and local guests and whatsoever. Great that you have interest in public international law in a very classical sense today. And we are happy but honored also that we have David Devlaeminck, or similar to pronunciation, with us. Dave, if I may say, is an associate professor at the School of Law at Chongqing University. That is not the Southwest University of Political Science and Law in Chongqing, which some of you know is our partner university, but it's, let's say, a neighboring university in Chongqing. His wife is teaching at Swapul, at our partner university. He is teaching at a neighboring university. But this is a very nice coincidence, so to speak, that we can actually benefit from both of you. Your wife teaching here this week and you lecturing today to us. And we're very happy to broaden, so to speak, our connection to Chongqing in this regard. Dave got his legal education in Ontario, in Canada, where he obtained a bachelor's and master's degree, and a PhD then in Xi'an in China. He will introduce himself in a second. And he is very much specialized in public international law, in general, international environmental law, law of water courses, and similar areas. Today we have a very topical, classical, but very topical issue at the same time, obligations erga omnes and erga omnes partes, which is South Africa versus Israel currently, but also Germany, yes. Of course, before the International Court of Justice, with regard to the Genocide Convention. We will hear about that. We are happy. Also happy that you choose such a very topical and very classical topic for our discussion. The floor
Thank you very much. Thank you very much for that very kind introduction. My name is David Devlaeminck, and as I was just introduced, I am Associate Professor at the School of Law of Chongqing University, neighboring but also competing university with Southwest University of Political Science and Law. Now, what I would like to do, I'll first give a little bit of an introduction to myself and my perhaps unusual background in the way that I came to international law. And then we'll talk about tracing the development of obligations erga omnes and erga omnes partes, looking at the various cases that erga omnes and erga omnes partes has been discussed from Barcelona traction, but also a little bit before then at the PCIJ, the Permanent Court of International Justice, and then going to South Africa. And you will notice there's a slight change in my title from what was advertised and beyond, because things just seem to keep popping up, most recently between Nicaragua and Germany. So first, a little bit about my unusual path to international law. I think it's really important for students to kind of hear where their professors, where the lecturers come from, and the kind of different ways that you can come to a career in international law or a career in research. So I actually don't have a formal legal degree in the way of a practicing lawyer would, but I actually started with a Bachelor's of Philosophy at the University of Guelph, which is a small agricultural university in Ontario, Canada. I then pursued a a master's degree, again in philosophy from McMaster University, a neighboring university just outside of Toronto. And while I was there, I did a graduate certificate program at the United Nations University, which is the research and think tank for the United Nations. And this specific institute focused on water, environment, and health. So then I began to transition from philosophy, policy and politics into international law. I was looking at the responsibility to protect and humanitarian intervention and the human right to water. And then eventually I made the giant move from Canada to China where I did my PhD at Xiamen University, which is a university in southern China across the coast from Taiwan. And there I worked on transboundary freshwater resources and the law of international watercourses with my former supervisor, Professor Patricia Wouters. And then after graduating in 2018, I stayed in China and I'm now located in Chongqing at Chongqing University. Now at Chongqing University, I do research on transboundary water, I do research on international law, but I also like to dabble into general international law, general international legal principles. My 2021 book is Reciprocity and China's Transboundary Freshwater Resources, looking at how we interpret the law of international watercourses through the lens of reciprocity as a legal principle. I also teach in international environmental law, coach our Jessup team, and collaborating with researchers in China and abroad, and also do some work with the American Society of International Law, among others. The reason that I wanted to include this slide is because of, here, can I get a little laser pointer? Forget it. The Jessup. The Jessup is really what got me into this topic of Erga Omnes and Erga Omnes Partes. I've been coaching our Jessup team for the past 6 years, and it seems that every year that we have a compromis, a case, Erga Omnes or Erga Omnes Partes becomes part of our pleading in one way or another. It is coming up again and again across a variety of different topics, and I also find significant relevance for my topic in international environmental law and the law of international watercourses. There appears to be a slide missing, but I can make up for that. There is, in the next few slides, and probably around 20-25 minutes, what I would like to do is trace the development of Erga Omnes and Erga Omnes Partes through a look at the way that the court has discussed it across a variety of different cases, going all the way back to 1923 with the SS Wimbledon, and coming all the way to present day in Nicaragua versus Germany. We'll first discuss that the historic origins at the court through various cases. We'll then discuss a period of expansion where the court has made various decisions that confirmed a variety of different Erga Omnes and Erga Omnes Partes obligations. And then we will look at the more modern cases, South Africa versus Israel, Nicaragua versus Germany, Gambia versus Myanmar, where Erga Omnes and Erga Omnes Partes appears to have solidified and been accepted by the court as a method of standing. I would then, if you would indulge me, like to link this back to my own topic and something that I'm looking to research on in the future, relating it back to international environmental law, international transboundary freshwater resources, and starting to just ask some preliminary questions that I might and that others might look into in the future. So thank you very much for having me here. This is a very classic international law topic, but as you might guess, I'm not a very classic international lawyer. So please, if you can indulge me for the next few minutes, I very much look forward to our discussion at the end. With the ongoing conflict in the Gaza Strip between Israel and Hamas, on December 29th of 2023, South Africa instituted proceedings against Israel at the International Court of Justice. South Africa is a state far, far away from the conflict. They do not claim to be an injured state. They do not claim to have been specially affected by the conflict. Instead, they base their argument off of the Article 9 of the 1948 Genocide Convention, which states that disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any other acts enumerated in Article 3, shall be submitted to the ICJ at the request of any of the parties to the dispute. Through this provision and related prohibition on genocide within the Genocide Convention, South Africa argued that they are entitled to bring the case to the court, that they do have standing, and that the obligations of the Genocide Convention are obligations erga omnes, in this case erga omnes partes, particularly the prohibition on genocide. Furthermore, they requested provisional measures. You can see a picture here of Africa's council, as well as Israel's council. Now, in its judgment on those provisional measures, the court noted that Israel did not actually challenge the standing of South Africa, instead arguing that a dispute between South Africa and Israel did not exist. However, they also reaffirmed that states indeed do have a common interest in upholding the Genocide Convention, and indicating that any state party to the Genocide Convention may invoke the responsibility of another state party, which includes standing in the court. They also granted South Africa's request for provisional measures, but where did this concept of erga omnes and erga omnes partes come from? Where do we look historically in the court for its beginnings, and what does it mean, and what are examples of obligations erga omnes and erga omnes partes? So we'll first look at some of the beginnings of erga omnes. We'll look at this period of slow expansion, then general acceptance with a bit of a question mark there, and we'll have some preliminary observations on different types of erga omnes, different ways to identify obligations erga omnes, and then we'll talk a little bit about the functions of erga omnes, looking first at standing, but also trying to go beyond standing. Three stages of erga omnes and erga omnes partes appear to be relevant, or appear to be illustrated in the cases of the court. We have very early cases beginning in 1923 with the SS Wimbledon at the Permanent Court of International Justice. We then have the 1966 Southwest Africa case and the 1970 Barcelona traction case, which is often thought of as one of the beginnings of erga omnes, but is really only where it was first clearly defined. We then have a period of slow expansion, but also identification of different types of obligations erga omnes and erga omnes partes through the East Timor Wall Advisory Opinion, at the ITLOS, the International Tribunal for the Law of the Sea, activities in the area advisory opinion, the prosecute or extradite case, the whaling case, and nuclear disarmament case. We then get into more modern cases where erga omnes and erga omnes partes appear to be generally accepted. In the genocide case between Gambia and Myanmar, in the genocide case between South Africa versus Israel, and in the more recently alleged breaches to the Genocide Convention case between Nicaragua and Germany. Now, this is not a complete list. Many, many cases at the ICJ deal with erga omnes or erga omnes partes in one way or another. But these are some of the most prominent cases that help us to develop and better understand the way that the court is talking about erga omnes and erga omnes partes. So we can go all the way back to 1923 to look for one of the earliest references to the concept of erga omnes and erga omnes partes, beginning here in Germany, when in 1923 a British ship, which was chartered by a French company, it was called the SS Wimbledon, was transporting munitions which was destined for Poland. It wished to pass through the Kiel Canal, but was denied by German officials, whereas the French ambassador requested its passage based upon the Treaty of Versailles, Article 380. The German officials argued that its neutrality order prohibited the transport of this type of cargo, which would be destined for Poland. Now, in its decision, the Permanent Court of International Justice said that the first question to be considered is whether proceedings could be instituted by the four governments who had done so: Britain, France, Italy, and Japan. And the court stated that it has no doubt that it can take cognizance of the application, and that it will suffice to observe the purposes of this case that each of the four applicant powers has a clear interest in the matter of the case, even though they may be able to adduce a specific prejudice or any pecuniary interest. In the event of a violation of any of the conditions of Article 380 to 386 of the Treaty of Versailles, or of disputes as to the interpretation of these articles, any interested power can appeal to the jurisdiction of the court. Now, this was based off of an interpretation of Article 386 of the Treaty of Versailles, which emphasized that any interested power can institute proceedings. And as such, it recognizes this common interest and an obligation owed to all of the parties of the treaty. But in the next case where this concept emerges, we see a rejection of erga omnes, or an actio popularis, a case brought in. The concept erga omnes was not entirely accepted at this time, evidenced in this case, where on the 4th of November, 1960, Ethiopia and Liberia instituted proceedings against South Africa, indicating that it had violated its mandate over Southwest Africa, which is now modern-day Namibia. Now, in this case, interpreting the jurisdiction clause of the League of Nations mandate for Southwest Africa, the court took a more restrictive approach. That the obligations owed under Article 72, which we can see here on the right, is owed to the League of Nations, not its member states individually. And in this sense, they rejected this type of actio popularis, the ability of a state to raise a case in the public interest. The concept of erga omnes was more clearly stated and defined for the first time in the 1970 Barcelona traction case, involving Belgium seeking compensation for the damage caused to its nationals who were shareholders in the company Barcelona Traction, Light and Power Company Limited, as the alleged acts were committed by organs of the Spanish state. Now, while erga omnes and erga omnes standing did not form a component of the final judgment, the court defined the obligations within its judgment as follows. As obligations of a state towards the international community as a whole, they are by their very nature the concern of all states, and that all states can be held to have a legal interest in their protection. They are obligations erga omnes. They then provided an incomplete or non-exhaustive list of candidates for erga omnes obligations, including the prohibition on aggression, the prohibition on genocide, the basic rights of the human person, protection from slavery and discrimination, and offered a distinction between treaty-based, erga omnes partes, or general international law, customary international law, erga omnes obligations. In the judgments that followed, there was a slow expansion of the concept of erga omnes as, through various cases, the court made note of different obligations erga omnes or erga omnes partes. In the East Timor case between Portugal and Australia, where Portugal claimed that Australia had failed to protect and respect East Timor's right to self-determination, the court indicated that the right to self-determination is of an erga omnes character. It also clearly stated that the erga omnes status of a norm does not trump the consent of the states to be brought to the court. In the 1996 judgment on the genocide case between Bosnia-Herzegovina and Serbia and Montenegro, the court confirmed that the rights of the Genocide Convention are erga omnes and that all states have an obligation to prevent and punish genocide. In the Wall advisory opinion, the court provided that obligations of international humanitarian law under the 1949 Geneva Convention for the protection of civilians are of an erga omnes status. This trend continued, but also began to be found in other courts and other dispute settlement bodies. The International Tribunal for the Law of the Sea, for example, advisory opinion on the activities in the area, affirmed that obligation to preserve the marine environment of the high seas and the area is an obligation erga omnes. Finally, in 2012, in the prosecute or extradite case, where Belgium filed suit against Senegal for granting Hissène Habré, the former president of Chad, asylum, the court indicated that Article 6.2, to determine the facts, and Article 7.1, to prosecute or extradite, of the Torture Convention are an erga omnes partes character, owed to all 174 parties to the convention. We also see this codified in the 2001 draft articles on state responsibility. While they are still considered draft articles, many of the provisions that are contained within the draft articles are considered codifications of customary international law. Now, Article 42 and Article 48 provide for the invocation of state responsibility, with Article 42 first providing that injured states, those either directly affected or who can be specially affected. And then Article 48 goes on to indicate that non-injured states can invoke responsibility if the obligation is owed to a group of states and the obligation is for the protection of a common interest, or owed to the international community as a whole. Now we're moving on past this second stage towards the more modern cases, towards general acceptance. 3 pending cases before the court. And there seems to be a more general shift towards acceptance. In the Gambia versus Myanmar genocide case, the court reaffirmed that erga omnes partes character of the obligations under the Genocide Convention. It also added an assessment that if these obligations required a special interest to invoke responsibility, that they would not be able to uphold such obligations and make such a claim. In other words, violations of the Genocide Convention, if they were not of erga omnes character, would go unchallenged. In elaborating on its position, it utilized an expansive interpretation of the compromissory clause of the Genocide Convention, interpreting Article 9 as allowing any of the parties to the convention to have standing. But throughout this period, there was also various dissenting opinions, and various judges wrote that they had opposed the idea of erga omnes or erga omnes partes. In 1974 nuclear test case, Judge De Castro wrote that obligations erga omnes should be taken cum grano salis, with a grain of salt. Judge Oda, in the 2007 genocide case, questioned whether the court would be an appropriate forum for such obligations and such provisions under the Genocide Convention. One of the most vocal critics, Judge Xue Hanqin, wrote extensively on the topic in her dissenting opinion in the 2012 prosecute or extradite case, arguing that the concept goes beyond treaty interpretation, against the jurisprudence of the court. Now, we should note that while the court does not have to follow their own jurisprudence, they may wish to do so for an act to maintain consistency within their judgments. Finally, in this dissenting opinion, Judge Ad Hoc Sur wrote out that the concept of erga omnes is ill-founded, with a poor foundation, and unjustified by the court in that case. Now we begin to come full circle. In spite of these obligations, South Africa versus Israel case illustrates that, at least as it relates to the Genocide Convention, erga omnes and erga omnes partes has now generally been accepted by the court as a method of standing in the court. In its order on provisional measures, the court noted that Israel, the respondent, did not challenge South Africa's standing. While this reflects past judgments, of note is Judge Xue's not dissenting opinion, but her declaration that has been attached to the judgment, in which she writes, in my view, this is the very type of case where the court should recognize the legal standing of a state party to the Genocide Convention, to institute proceedings on the basis of erga omnes partes, to invoke the responsibility of another state party for the breach of its obligations under the Genocide Convention. So even its most fervent critic is now accepting the possibility of erga omnes obligations. But as we see in the most recent trend, it's all under the Genocide Convention. In the most recent case, pending between Nicaragua and Germany, also again in relation to the conflict between Israel and Hamas, offering an opportunity to once again explore the concept of erga omnes and erga omnes partes, this time, however, in relation to the prevention of genocide and the role of other third states. In the verbatim record on April 15th, but Nicaragua in its oral proceedings invoked multiple different obligations, erga omnes, including those under the Genocide Convention, as well as those under the Geneva Conventions. Interestingly, it also invoked the general obligation to cooperate as a general principle of international law, and as it relates to the aforementioned obligations under the Genocide Convention and the Geneva Conventions. Now, similar to South Africa versus Israel, the respondent, in this case Germany, did not challenge the standing of Nicaragua. While the court did not provide for the provisional measures that Nicaragua had requested, it also did not touch on the topic of erga omnes, or erga omnes partes. In that judgment, so from this brief survey of the various cases of erga omnes and erga omnes partes, we can see two different types, erga omnes, which are typically derived from customary international law, and we will also note that these have not yet been accepted by the ICJ case law as a method of standing. We see erga omnes partes under the Genocide Convention as one method, but we don't see erga omnes obligations under customary law at this point yet. We also have erga omnes partes, which are derived from treaty law, such as the Genocide Convention, the Geneva Convention, various human rights instruments. Now, some of these norms also have jus cogens status. They are peremptory norms of international law that cannot be modified by treaty, such as the prohibition on genocide. Now, while these jus cogens rights necessarily have an erga omnes character, the reverse is not necessarily true. Not all erga omnes obligations are necessarily jus cogens obligations. Now, we also have some, but quite limited, guidance on the identification of obligations erga omnes and erga omnes partes. While they continue to grow, although slowly, there is limited guidance on how we know and how we can identify which obligations have such a character. Now, the Barcelona traction case appears to give us two criteria. The importance of the rights involved, which you can see here on the top in blue, and also that all states can be held to have a legal interest in that obligation. And then it provided this non-exhaustive list on the right, again in blue. In later cases, it affirmed, but also expanded upon this list. In the prosecute or extradite case, for example, the court affirmed the necessity for all states to have a legal interest in their compliance, but then goes on to make the note that such obligations, if a special interest were required, would be unable to be upheld, as no state would be able to make a claim for those rights, and they would thus go unprotected. However, what is a source of some debate is whether or not these criterion are cumulative, or if in some cases only some can be met to meet an erga omnes or erga omnes partes character. Scholars have also attempted to provide some assessments of the different characteristics of obligations erga omnes and erga omnes partes. Maurizio Ragazzi, in his book, did a comparative analysis of the erga omnes obligations found in the Barcelona traction case, and through that analysis, he identified 5 different characteristics, including that they are narrowly defined obligations, which are often negative obligations or prohibitions, like the prohibition on genocide, that they contain both obligations or duties. They are derived from rules of general international law, which are sometimes of a jus cogens nature, and they are codified by a treaty with often very high participation. And they are often instrumental to the various political objectives of the time. But given the age of this assessment from 2002 and the various expansion of the concept of erga omnes and erga omnes partes over the past few decades, it's certainly worth reassessing what the characteristics are of erga omnes and erga omnes partes in this broader landscape. The protection of the marine environment, for example, does not appear to be merely a prohibition on activities that would endanger the area or the high seas, but requires positive action by states, at least in some circumstances. And this leads me to our final point, that functions of obligations erga omnes and erga omnes partes has typically been related to the standing of a state in the court. However, there is some movement towards a broader understanding of erga omnes and erga omnes partes in the sense that they might create other types of obligations for states beyond a standing in the court. Do states, for example, have the obligation to respond to breaches of obligations erga omnes partes? Oscar Schachter, in his 1991 book, International Law in Theory and Practice, wrote that erga omnes and erga omnes partes may well have the desirable effect of making governments more conscious of their interest in the observance of international law and of their legal right, and in some cases legal duty, to take action through collective countermeasures and in political and judicial bodies to combat grave violations. This was further developed in the Wall Advisory Opinion, which states that it is also for all states, while respecting the Charter and international law, to see to it that any impediment resulting from the construction of the wall to the exercise by the Palestinian people of its right to self-determination is brought to an end. In my own work, however, I'm also starting to ask these types of questions, particularly as it relates to international environmental obligations, but particularly in transboundary freshwater resources. This might not be a topic that many of you are familiar with, but it's incredibly important as 310 international river basins cover 47% of the Earth's surface, 52% of the world's populations, and approximately 150 states have territory in one of these transboundary basins. We also have significant transboundary groundwater or aquifers, 468 to be precise, which cross state borders around the world. And when we look to the international law that is relevant in this area, we see two global water conventions, the 1997 Convention on the Law of the Non-Navigational Uses of International Watercourses, and the 1992 Convention on the Protection and Use of Transboundary Watercourses and International Lakes. These are framework agreements, which is a very common approach in international environmental law that provide a more broad set of rules and obligations that can be applied at the specific basin level in more specific treaties. And they're also recognized as codifications of customary international law. Now, thank you very much for listening to me on the topic of erga omnes and erga omnes partes, but at this point in time, I'd like to go back to my specific topic and to give a little bit of a hint about where my own research might be going in the next little while. Now, when we look to transboundary freshwater resources and the law of international watercourses, we often see that there's 5 different types of rules within treaties. We have rules on scope, which tells us what types of waters this treaty applies to. Does it apply to a river? Does it apply to a lake? Does it apply to groundwater? Or does it apply to some combination of them all? We see substantive rules. Primarily, we have 2. That each state has the right to an equitable and reasonable use of the freshwater resource, and that they also need to respect that similar right of other states, and the due diligence obligation not to cause significant harm. We have various procedural rules, particularly prior notification, consultation, and information sharing, and institutional mechanisms and the obligation or recommendation to establish an institutional mechanism which can act as a hub of cooperation. And then we have provisions on dispute settlement, allowing for both diplomatic but also judicial methods. Now, as I have been working with Jessup over the past few years, thinking about obligations erga omnes and erga omnes partes, I am also beginning to see this reflected in my own area of international law. That there are different possible candidates within international water law for obligations erga omnes or erga omnes partes. Now, whereas some scholars, like Agnes Chong out of the Chinese University of Hong Kong, says that equitable and reasonable use and the due diligence obligation not to cause significant harm are not possibly erga omnes or erga omnes partes, I myself might not be so quick to make such an assessment. In his work, Owen McIntyre from the University College Cork in Ireland, he writes that perhaps solidarity within transboundary freshwater resources is an erga omnes or erga omnes partes character. In another article written by Professor Patricia Wouters and Dan Tarlock, they write that the duty to cooperate might be an erga omnes character, similar to what Nicaragua has argued in the Nicaragua case, but related to Genocide Convention, and in this case related to environmental obligations. This, however, all raises various questions of scope. We usually discuss obligations of erga omnes to the international community, but if we're talking about a transboundary river basin, would it be to the basin states, or would it be to the international community as a whole? Perhaps we are, as we further develop our understanding of global environmental, of the way that the global environment works, we're starting to see those connections between specific regions and specific basins and the international community as a whole. While this could be utilized to institute proceedings, as we could see as a method of standing, if these obligations were obligations erga omnes, could there not be also other obligations that might arise? Finally, if it's the duty to cooperate as an obligation erga omnes, might this go beyond standing and providing the impetus for compliance procedures under international environmental law, or hydrodiplomacy, or other preventive measures to prevent conflict in the first place? So, a few concluding remarks. The concept of erga omnes has been developed very slowly over the past few years, and likely rightfully so. But now it appears to be generally accepted. It has experienced this slow expansion, and while we still have limited guidance, what is clear is that each time the court will conduct a case-by-case assessment. It also has strong significance for this country here of Germany, as it kind of begins and most recently ends with Germany at an international dispute settlement body. So certainly something that German scholars are paying attention to. And it typically entails the standing of a state, but I want to start to ask questions if erga omnes partes could possibly go beyond the question of standing, to perhaps do some blue sky research and think of how erga omnes or erga omnes partes might work outside of the courtroom and how we might implement those types of procedures elsewhere. Thank you very much. Very much looking forward to your questions and discussion.
Thank you very much for this highly interesting presentation. The floor is open. Please, you manage the discussion by yourself, I would suggest.
Of course.
Please. Thank you very much for this very intriguing talk. The question is, I mean, it's always something that's tricky. I mean, to have the erga omnes dimension on the one hand and the jus cogens on the other. But I'm wondering, I mean, as you, I think, aptly pointed out, that erga omnes norms, in a way that is a bit misleading, because the norm is there erga omnes anyway. As such, the material obligation applies to all the parties of a treaty, for instance. So you don't need the erga omnes concept in that sense. So what it actually seems to mean, and you've aptly pointed out in the history of, is it's about the standing issue. And then I'm wondering, how could it go further than that? I mean, I would say probably not in terms of any material obligations, because they are there anyway, you know, unless you want to say they also apply to states that have not subscribed to them. But then you want to use cogens dimension or something else, and I don't see any indication for that. compliance, I see where you're coming from to say if you allow for standing, then it's also a step into saying everyone has an interest on these claims being made, and that could also mean that everyone has an interest on those claims once they have been decided by a court to be complied with. But it's a far way, it's a stretch maybe a little bit to get from A to B. And in the end, doesn't it all depend on what states imply when they create those norms, whether it's custom or treaty? And isn't it then the only task of courts to kind of infer from what was meant when those norm was generated? And then if it's something, I mean, a candidate maybe for Erga Omnes without being use cohens would be some rules on protection of embassies, for instance, which is probably not use cohens, probably Erga Omnes. So it seems to be inherent in the character of those norms that everyone who runs an embassy, even though it's not your embassy, I mean, your embassy is maybe around the corner, so everyone has an interest in those rules being safeguarded. So either they are so important that they also use cohens, or it's so natural that everyone is interested, which is inherent in the norm we're talking about. So maybe we could make more of an argument on the inherent of the kind of the character of the norm as such, which then comes with the the necessity to also for anyone to bring their claim, whether it's because it's so fundamentally important, or whether in practical terms everyone is concerned by a violation, even though it's not your embassy. I don't know whether that how much traction that can have, but it's partially a comment, partially a question whether you think you could make kind of construe an argument out of that, but also whether you see limitations that come with that kind of looking at things.
So I fully admit that this research is very, very early stages, and I really thank the department for kind of pushing me to start doing the research and thinking about this topic and kind of getting my head around what is actually a very, very complex and legally theoretical way that norms work. And as a Erga Omnes partes, and also as use cohens. I think what I'm thinking of when I think of international environmental Erga Omnes, we can look to like the protection of the marine environment and the protection of the area as one example. And so I see similarities between this specific Erga Omnes or Erga Omnes partes. I think they would call it Erga Omnes based on customary international law. And other environmental norms.
Public interest norms, for instance.
Yeah.
Like my academics who I used to write on these public interest norms in the field of the environment.
And so in my area of transboundary freshwater, we have the concept of a community of interest. So that is typically, if we have the Danube River, for example, that would be all the states that share the Danube River. But I think with our understanding of the way the Earth works and the atmosphere works and the interconnections between environment have this broader understanding that it might go beyond just the Danube River basin or a specific body of water to begin to consider what the role of other third states in that situation would be. And in international environmental law, we don't see a lot of reference to international court cases. It's often not very a positive way to solve our environmental issues, which we usually want to have cooperation. We don't want to have adversarial court cases and conflict. So we typically reach for compliance mechanisms. We typically reach for these other ways to solve these conflicts. So just my early thinking is that it might play some type of role in this, but it's still a very long way to go on this research for me. So I'm really very appreciative of your comment and question, and kind of really hope that you will all kind of push back and help me kind of understand this better. Christian?
And I was wondering, maybe following up on a more procedural aspect, there are two aspects. First, Nicaragua versus Germany is a very interesting decision. As you might know, the court hardly did any law, but based the decision on preliminary measures exclusively on facts. Why? Probably in order to prevent that they are setting a standard that cannot be fulfilled and therefore will not have the possibility to intervene in that conflict, Israel versus Gaza, anymore in the future. Probably. And also the facts were pretty clear, as all of 98 or whatever percentage of the support of Israel in the last, whatever, 2 years was not for the purpose of the conflict, so to speak. So the fact but anyway, it's quite interesting because in all cases of preliminary measures we had so far in the history of the court took time to elaborate on the legal standard. So that's interesting, and it might be connected with the fact of Erga Omnes and choose, not as South Africa with Israel, where we have only one state not being involved, but here we have, so to speak, two states not being involved, at least not directly in the conflict. Secondly, and that relates, and that's closely related, what about monetary gold in this regard? As I don't know whether students saw monetary gold in jurisprudence of the court from the 1950s, where the court said that if significant legal interests of the third state are involved in a given dispute, then the court may not decide on that dispute, to put it simply, if the third state is not involved in the proceedings. So in this case, you cannot, the argument would go, render a decision in Nicaragua versus Germany if Israel has significant interest and is not part of the proceedings. The court didn't touch upon that, not at all, not a word in its judgment. Why that's speculative, of course? Maybe because we do not have an answer. What to do in Erga Omnes cases before the court, where none of the parties involved is directly involved in whatever the dispute is, but most of the parties involved are, so to speak, I don't know, can you say standing for the plaintiff as well, for the respondent as well, where both are before the court because of Erga Omnes, so to speak.
Well, and it's also a unique opportunity for the court. So we've seen how it talks about consent in Erga Omnes.
Yes,
but now it's how do we interact?
Yeah. How do we reconcile that? If we accept this broad interpretation of Erga Omnes, namely, and it has been accepted, Germany had kind of a complicated position in the Nicaragua case, because in the Myanmar Burma case, it supported Erga Omnes' standing interpretation explicitly, and therefore it was in kind of a complicated position to deny the possibility here for Nicaragua to win the case. But anyway, if we accept this broad interpretation of Erga Omnes with regard to standing, and it seems to be set in case law, how do we reconcile third-party interests, namely with regard to monetary gold? And as I said, the Nicaragua versus Germany decision on preliminary measures seems, because it's based purely on facts, no law at all in that decision, seems to indicate that the court does not have an answer on that.
I obviously do not have an answer for that. If the court does not have an answer, I also likely do not have an answer. But I think, just coming off the top of my head, you also kind of have to wonder if the monetary gold principle is an obstacle to upholding an Erga Omnes obligation and having standing in the court. Then again, we kind of come up to these special types of norms that are fundamental norms of international law. And then various third states do not have any way to uphold them. So if we cannot talk about these because of monetary gold principle, then I think these kinds of Erga Omnes obligations and these cases will go unchallenged once again. Yeah. A very big question that our young colleagues in the room can assess in LLMs and PhDs.
Open questions.
Yeah.
All right, thank you for your wonderful presentation. But I want to know that, is there any similarity between the case concerning Barcelona attraction and the South Africa-Israel issues? I think this one is clearly civil matters based on the damage against their nationals, yes?
Yeah, so my understanding is that I think there would be very few similarities. To be honest, the concept of Erga Omnes was not formed a fundamental component of the Barcelona traction judgment. They're actually comparing different types of obligations, and then they elaborate upon erga omnes in that case. So we only raise Barcelona traction in this instance, not because it has similarities to the Genocide Convention today, but because it's the very first time where erga omnes was more clearly defined in the court.
To show the evolution,
Yeah,
the
exactly.
evolutionary shift.
Yeah, yeah, just as a starting point, and then to see where it comes from there.
All right. Do you think that the South Africa has a vested interest or locus standi to bring suits or allegations before the ICJ against the Israel? Is there any?
For Genocide Convention?
I know that for the Genocide Convention. Is there any? Do you think that there is a political interest behind the South Africa's allegation, or purely it's humanity matters?
Well, I think we could always have suspicions either way.
All right.
But I think in their court case, they're not saying that they have a political interest. They're saying that they have, they're trying to uphold this common legal interest in the Genocide Convention. I think if you want to dig deep into it, maybe you can make that argument. But my own understanding is that they themselves are not claiming they have a special political interest. They themselves are saying we have a legal interest in upholding the obligations of the Genocide Convention. And those obligations are specific, erga omnes, partes.
Is that your stand on this?
Sure, yes. We have a few minutes remaining, 7:50, oh sorry, not 7:52, that's China time.
Good, thank you very much.
Thank you very much for having me.
Thank you very much. Law After Lunch is always planned for 1 hour sharply, and we are almost 1 hour sharply. We got a very good insight in a very classical, but very topical on the other side, a challenging question, and we leave the room with more questions than answers, which
Usually
is
the
good,
case.
and that's the way academic discourse should be. So thank you very much for being here.
Thank you for hosting.
And for the presentation, and thank you for being here in the audience. And we have the next Law After Lunch, I forgot, of course. When?
I think the
In June, no?
6th of June.
Beginning of June. Have a look at the advertisements and follow us on social media so you know what's going on. That was the advertisement block. Thank you very much. Have a nice day.